I have the genuine honor to speak to you today about the most important document in our country's history. Today's a day to celebrate that document, being Constitution Day. And today's Constitution Day because 39 delegates to the Constitutional Convention signed the Constitution on September 17, 1787. September 17th was originally called Citizenship Day when it was established by Congress in 1952. 4 years later, the week beginning September 17th became Constitution Week. And it wasn't until 2004 that Citizenship Day became Constitutional Day. And today's a day to celebrate the Constitution, and one way to do so is to talk about what's actually in this document and why the contents are so important to all of us in our everyday lives. I respectfully submit that the term enduring Constitution is the most appropriate way to talk about what we're honoring today, especially considering that the United States Constitution is now the oldest written Constitution in the world. Not much has endured since 1787. The way of life certainly hasn't. Cars, airplanes, radios, televisions, cell phones, and the internet were all many years away, and sometimes centuries away from being invented yet at that time. Electricity wasn't even invented until 100 years after our Constitution was signed. In 1787, there was no such thing as antibiotics, so almost any sickness could have been deadly. The average life expectancy back then was 35 years. Now it's more than double that. It's not surprising then that the population of the United States is about 85 times greater than it was back then. Since the Constitution was signed, our country has been through multiple wars with other countries, and even a very bloody war against each other within our own borders. There have been economic, cultural, legal, and political changes over more than 2 centuries, which are too many to mention, and our Constitution has endured all of them. The Constitution has been formally amended 27 times, the first 10 of which came as a group, known as the Bill of Rights, that were passed in 1791. The most recent constitutional amendment concerns how members of Congress are paid, and that was ratified in 1992. The Constitution has changed in profound ways, such as banning slavery and clearly ensuring that all people, regardless of their race, or their gender, or their income level, have the right to vote. It's also changed to create an income tax and direct election of senators, 2 things you may have thought always existed, but didn't exist until the Constitution changed to allow those things. It's also changed a few times with respect to the office of the President of the United States, fixing the inauguration date of January 20th, creating a term limit for anyone who's elected to that office, and establishing a succession plan if the office becomes vacant or if the president becomes disabled. So our Constitution has endured, but it's also changed. And despite all those amendments, significant parts of our Constitution have stayed exactly the same. We still have 3 branches of government that Articles 1, 2, and 3 of the Constitution gave us. These articles created a system of divided government, with checks and balances on power. Ambition must be made to counteract ambition, is what James Madison wrote in Federalist number 51, and this makes the United States somewhat unique, back then and now. Many countries rely on just one person to lead their government, a head of state with total power, who dare not question if you knew what was good for you. Our country was founded because of frustration with that type of power in one person. That's where the legislative, executive, and judicial branches of government speak to. Now, the President of the United States is thought of as the most powerful person in our country, and in many ways that's true. But the power of that office is constrained in many ways by the Constitution. Courts have the power to invalidate an action of the president if they find that action is unconstitutional. Congress can pass laws that curtail the president's power, and they can cut off funding for executive branch projects if Congress disapproves of those projects. The legislative branch is even authorized to remove the president from office, as they attempted earlier this year in the impeachment process. No one questions whether any of these things is legitimate precisely because we've been accustomed to an enduring constitutional principle of divided government. I think one of the most significant things that can truly be said about the Constitution is that it has largely defined what is American and what is un-American. Now consider these examples. But perhaps if you take long enough, you can think of someone who dislikes the current president of the United States and is very vocal about that opinion. Perhaps you won't have to think too long to come up with someone who fits that profile, and perhaps you are even the person who fits that profile. But in any event, no matter who the president is, there will always be people you know who are showing their opposition to that person loudly and proudly. This is part of the American way of life. Now, see if you can think of someone who is charged with a crime solely because they opposed the president. Charged not because they harmed or threatened another person while opposing the president or damaged property or broke some other law. That's not what I'm talking about, because I think we all agree there's legitimate laws that prevent assaults and damaging property, other type of behavior. You have to think of someone who's actually been arrested solely because they spoke out against the president. You can't think of anyone who fits this profile because opposing the president is not and must never be a crime in this country. The First Amendment protects our right to speak freely. Even the press is protected by the First Amendment. So no matter how much a president might dislike what is said and written about current events, the press will never be silenced. That would be un-American, and that would be unconstitutional. Let's look at one more example. See if you can think of someone you know who has been questioned by the police. Now imagine that during that questioning, the officer said something along the lines of, by law, you're required to answer every question that I'm going to ask you. You probably can't imagine that because in America, it's just the opposite of that. You have a constitutional right to remain silent. And that's what's in the familiar Miranda warning that officers tell suspects that they have the right to remain silent. You can probably imagine a scenario where a crime has been committed and an officer makes an arrest. But can you imagine a world where the officer is the judge and the jury deciding whether the suspect is guilty or innocent and imposing the punishment? How about a scenario where the suspect can't have an attorney? It's hard to visualize any of that because that would be unconstitutional and un-American. The Sixth Amendment provides for due process of law. That means anyone accused of a crime is innocent unless and until, if ever, they're proven guilty beyond a reasonable doubt in a court of law by a jury of their peers. That amendment also guarantees the right to a speedy and public trial by jury and the right to have a competent attorney defend you at trial. Even if that person can't afford an attorney, the government pays for their attorney in order to make sure that constitutional amendment has some teeth to it. I could go on with more examples, but the key point here is that the constitutional protections we've all enjoyed during our lifetimes, and sometimes we take for granted or don't realize are there, are the same protections that have been in place since the Bill of Rights was passed in 1791, shortly after the Constitution was signed. That these protections have endured throughout all this time while so many other things have changed is truly remarkable. That these parts of the Constitution have become so deeply embedded in the American way of life that we can't imagine any other way is truly something that we should be celebrating. Now, to be fair, not everyone agrees with my idea of an enduring Constitution. There are people with an opposing viewpoint that see what we're celebrating today as a living constitution as opposed to an enduring constitution. As you might have guessed from what I've said so far, I disagree with the idea of a living constitution. I'm going to tell you why I do. But before I do, I think this is a good time to pause and say a word about civility in our discourse. In his book, A Republic, If You Can Keep It, Supreme Court Justice Neil Gorsuch said that the United States is currently facing a civility crisis. Justice Gorsuch said, quote, "Without civility, the bonds of friendship in our communities dissolve, tolerance dissipates, and the pressure to impose order and uniformity through public and private coercion mounts," end quote. Justice Gorsuch said that George Washington had a copy of 110 Rules of Civility that were written by the Jesuits in 1595. And he paraphrased his favorite rule as saying, quote, "Do not speak so closely to another person with such enthusiasm that you bedew the other man with your spittle." So not only is social distancing a great way to prevent transmission of the coronavirus, it also has been a great way since 1595 to prevent transmission of incivility. But what I want to make clear is that the issue I take is with the concept of a living constitution, not with anyone who holds that opinion. I have many friends and colleagues who believe in a living constitution. I view them as all good people. The key to civil discourse is separating the issue from the person. I'll give you an example of what I mean by that. I once watched on TV an interview with a longtime Major League Baseball umpire. And the questioner asked him, "How do you decide when to throw a player or a manager out of the game?" And as this question was being asked, you can see on TV all these pictures of this umpire being yelled at by players and managers, being dirt kicked on him. And the umpire said, "Well, I have no fixed rule, but usually the sign that somebody's about to get thrown out is they've said the word 'you.'" The umpire said, "I'm fine with loud complaints about a call that I made or the job that I'm doing as an umpire, but once the complaints start to become about me personally, then I've had enough and I'm likely to throw that player out of the game." That's a key rule for civil discourse, too. We need to stick to phrases such as, "This is a bad or terrible idea," or "This is a bad or terrible policy." When someone starts saying, "You are a bad or terrible person because of the belief you hold," that's when it's time to perhaps eject yourself from that conversation. So let's return to the idea of a living constitution with those principles of civility in mind. The phrase living constitution can be defined in a few different ways, but I think a fair explanation of what this means is that judges should interpret the Constitution in a way that allows it to resolve present-day disputes that the document doesn't directly speak to. Living Constitution supporters often describe the Constitution as too old or too outdated to apply to issues of our time. And this idea sounds very nice in theory, but in my view, it has numerous flaws in its application. Now, if you remember the hypothetical I gave you about a person speaking out against the president, I'm sure everyone would agree that any law banning this activity would be unconstitutional under the First Amendment. But now think about how people nowadays do most of their speaking. A lot of it's done through mediums like Facebook and Twitter. Those things weren't around in the 1700s when the Constitution or the Bill of Rights was signed. Those are relatively new ways to communicate. But the First Amendment, as written, still applies to them. There's no need to interpret it any differently than it was interpreted when it was written, because that protection for free speech endures throughout changes in the way people speak. How about the Fourth Amendment? That protects people's papers and effects. We don't need a living constitution to interpret this provision as protecting information stored on our cell phones, even though cell phones were definitely not around when the Bill of Rights was being signed. The protection against unreasonable searches and seizures endures through the way people changed how they store their papers and effects without the need to interpret the Constitution any differently or to add or delete any parts of it. The biggest and most fundamental disagreement I have with the idea of a living Constitution is when that theory is employed to either manipulate the Constitution or get around the Constitution in order to solve a present-day problem, which otherwise could or should be solved through the democratic process or the democratic branches of government. The Constitution contains an amendment process to add principles or protections that address changes in society. As I mentioned, there's been 27 amendments to the Constitution, and when you think about it in the grand scheme of things, 27 amendments is not that many over all of our country's history and all the changes we've gone through. We only have 27 amendments most likely because the amendment process is very difficult. Article 5 of the Constitution says that 2/3 of both houses of Congress and 3/4 of all state legislatures must ratify a constitutional amendment. When you add up all the people involved with all those votes, that's literally thousands of public officials all across the country, the red states and blue states, that all have to vote yes on any proposed constitutional amendment. That is a very grueling process. You can see then why a living constitution has so much appeal to somebody who wants change but doesn't want to go through it that way. It's much easier to convince 5 life-tenured justices on the Supreme Court to find that the Constitution requires the result you're looking for than it is to convince thousands of legislators all across the country to pass an amendment. The amendment process is the only way not only to add provisions to the Constitution, but to remove provisions from the Constitution. For example, the 18th Amendment, ratified in 1919, made it illegal to consume alcohol. But the 21st Amendment, ratified in 1933, repealed the 18th Amendment so we could all drink again. Now, sometimes the Constitution is the only thing standing in the way of a government solution to a proposed present-day problem. If you believe in an enduring Constitution, then the Constitution standing in the way is a fatal problem for any government solution unless they can go through the amendment process and get the Constitution changed. But if you believe in a living Constitution, then there's no problem, because you can use that concept to insert a provision into the Constitution that isn't there, or to ignore or get around a provision of the Constitution that is there but is inconvenient to the solution. And one way to understand what I'm saying here is to consider the case of Korematsu versus United States. Fred Korematsu was a 23-year-old Japanese American living in California in the 1940s. Following the attack on Pearl Harbor, President Franklin Roosevelt signed an executive order, which soon after became a piece of legislation, which required all persons of Japanese ancestry living in the United States to report to relocation camps. Well, Fred Korematsu didn't want to go to a relocation camp, so he was arrested and convicted of violating the law, even though not one person questioned Fred's allegiance to the United States. Korematsu appealed this conviction, and it went all the way to the United States Supreme Court. This should have been a very easy case for the court to decide correctly, but they didn't do it correctly. The Fifth Amendment guarantees due process, and the 14th Amendment guarantees equal protection of the law. And Fred Korematsu got neither, and he was arrested solely because he was a Japanese American. But the Supreme Court, instead of overturning Korematsu's conviction as unconstitutional, upheld it by a 6-3 vote. And the court's ruling was based on deference to the executive branch in a time of war. Sounds like a present-day problem that the Constitution was inconveniently standing in the way of solving. Although we'll never know for sure, we've never really tried to pass a constitutional amendment in the middle of a war, as that wouldn't be very feasible. I doubt that a constitutional amendment approving relocation camps ever would have passed in this country, even at the height of World War II. As proof of this, look to the Korematsu decision itself, issued in 1944. As I mentioned, it was a 6-3 vote, so 3 justices on the court didn't agree that was right. And look at what those 3 justices said when they dissented from that decision. Justice Owen Roberts wrote, quote, "I need hardly labor the conclusion that constitutional rights have been violated." Justice Frank Murphy, who was appointed to the court by President Roosevelt, whose executive order was being challenged, called the decision, quote, "legalization of racism." And finally, Justice Robert Jackson, who was not only appointed to the court by President Roosevelt, but also served as his Attorney General, realized the long-lasting effect of the decision when he wrote, "A military order, however unconstitutional, is not apt to last longer than the military emergency. But once the judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order, the court has for all of time validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. Every repetition embeds that principle more deeply in our law and thinking, and it expands it to new purposes." Now back to Fred Korematsu and what happened to him. The Supreme Court upheld his conviction, but he was eventually released from an internment camp in Utah after the war ended. He got married, he had 2 children, and he was 86 years old when he died in 2005 in California. In 1976, President Gerald Ford signed a proclamation formally terminating President Roosevelt's executive order, and he apologized for what happened, saying, quote, "We know now what we should have known then. Not only was the evacuation wrong, but Japanese Americans were and are loyal Americans." Korematsu's conviction was later formally overturned by a district court, and 2 years ago, Chief Justice John Roberts wrote, quote, "The forcible relocation of U.S. citizens to concentration camps solely and explicitly on the basis of race is objectively unlawful and outside the scope of presidential authority." Many have considered this statement to be the Supreme Court formally overturning Korematsu versus the United States, even if that case has been informally placed on the ash heap of history a long time ago. Now, I believe the Korematsu decision would have been 9-0 to overturn his conviction as unconstitutional if the justices at the time viewed the Constitution as an enduring Constitution with its principles contained therein, enduring through a war, as opposed to a living document to be interpreted in a way that best suited the proposed solution to a perceived problem during that war. In conclusion, I want to share a quote from one of the most colorful writers to ever serve on the United States Supreme Court, Justice Antonin Scalia. He once said the Constitution, quote, "establishes a rock, fixed principles to which society is anchored. Once you say the rock is floating, then it means whatever it ought to mean. You're not praising the Constitution. You're praising current society. And if you're celebrating that, you're not celebrating the Constitution." The enduring Constitution that I've talked to is unequivocally worth our celebration today. I want to thank you all for letting me share a few of my thoughts about the rock in which our society is anchored to. And I know there's some time, so if anyone has any questions, I'd be happy to take all of those now. So thank you again. Yes, sir.
So you say it's a concurrent set of living documents. So you believe that it's more concurrent now?
Could you speak a little bit louder? Sorry, it's saying.
You believe it's a concurrent document, like a concurrent set of a living document. So you said that the difference between one is interpretation.
Well, basically, the two things I'm talking about are ways of interpreting the document. The way that I support is the enduring Constitution, which you basically look to what the Constitution says, the issues that it addresses, and if it solves your problem, then it solves your problem, and that's great. But some problems the Constitution doesn't solve. And that's where, as a proponent of an enduring Constitution, I view that judges should end their discussion there and return it to the people in the democratic process, whereas people who view a living document view the document, and again, I'm kind of speaking for them, that it really should solve any issue that you bring before it, so you need to find a way for it to do that. And that's where I respectfully depart from that way of thinking, that the Constitution really doesn't solve every present-day problem. But if there is one that the Constitution should solve and doesn't, the amendment process is the way to go through that. And some problems don't even need to be solved by the Constitution or an amendment. They can be solved simply by a law passed by either Congress or a state legislature. So that's, in my view, the way those two competing ways to view the Constitution and how to interpret it, what they mean, and how they interact with each other. Any other questions? Yes, sir.
In your experience, what seems like a more popular belief of the enduring Constitution?
You know, I would say it's a pretty hotly divided issue. You know, there's plenty of people on both sides who hold those opinions, either enduring Constitution or living Constitution. So, you know, I'd hesitate to guess, you know, which one is more popular, other than to say there's significant support, in my view, on each side for that way of interpreting the Constitution. Other questions? And they don't necessarily all have to be about the Constitution. If you want to know anything about me or my background, and I can certainly tell you some more about myself and my background if you'd like, but I want to make sure that we are celebrating the Constitution today, so I don't want to make this about me too much. So if anyone has questions about the Constitution or about myself, I'd be happy to answer any of those. Yes?
What's the process like going through to be a judge?
Sure, well, that's a good question. So it's different for me.
What was the question?
Okay, sorry. The process, the question was, what is the process like to become a judge? So it's different at the federal and state level. I'm a state court judge, but at the federal level, the President of the United States nominates somebody to be a judge, and the United States Senate, by a majority vote, has to confirm that person. And if that person gets confirmed, then they serve basically for the rest of their life. The Constitution says good behavior, but most people have just interpreted that as essentially your entire life unless you get impeached. At the state court level, it's much different. You have to apply to a committee, which is at the district court level where I'm at, is comprised of 11 people. There's 5 lawyers who have to practice and reside in the district that the district court judge is from. And then there's 5 people who are not lawyers who live in that district. And then the 11th person is the judge in that district who has been the judge the longest, so the most senior judge. So those 11 people form a judicial nominating committee. And when there is a vacancy in a judicial position at the state court level, they have to apply to that committee. And the application is a very detailed written application. They ask you many questions about your personal history, why you want to be a judge. You know, it delves very deeply into your background. So everyone who wants to apply has to fill out that application. And then they have in-person interviews with everyone who applies. And the committee can ask them questions, and the person who applies can make a presentation to the committee, and then the committee votes in secret on who they're going to send to the governor. Now, in my case, there were 6 people who applied, and Judge Margaret Lindgren decided to retire. So the 6 of us all went through that process, interviewed with the commission in Winnebago County at the Decorah County Courthouse, the Winnebago County Courthouse in Decorah. And then the commission decided to send myself and Associate Judge Stephanie Rattenberg to the governor. And what that means is, so the 2 of us then go through an interview process again with the governor. And you have to fill out another written application for her. And you go through another interview with her in Des Moines at the Capitol and her staff. And then she picks one of the 2 people that the commission sends. So much different than the federal level, where the president kind of gets to decide at the start, here's who it's going to be. At the state level, 2 names come to the governor, and they have to pick one of the 2. When you get up to the Court of Appeals and Supreme Court level, then it's 3 people that get sent to the governor as opposed to 2. And the governor has to pick one of the 3. It's also different at the state court level in the sense that we do not serve for life. We serve for as long as we're retained. So every 6 years, we have to be on the ballot. So if you voted before, you've seen, usually it's the back of the ballot, the very last questions are a bunch of lists of judges. And you vote yes or no. Yes, meaning I want to retain this judge, in which case the judge serves for another 6 years and can go on the ballot again. Or no, in which case that judge's term ends at the end of the year and they have to go back to practicing law or doing something else. So that's another significant difference, at the state level than at the federal level. One final difference, not only do we only serve 6 years at a time, and for the Iowa Supreme Court, that's an 8-year term. So every 8 years you're on the ballot instead of 6. The other difference is, I mentioned federal judges serve for life. State court judges have to retire at age 72. You can kind of semi-retire, which is called taking senior status. And you can do that till you're age 78. And then you have to fully retire. So at the state level, there's some age restrictions. They tell you once you get to this age, you're either retiring fully or you're taking senior status, and once you get to 78, then you're just done. Where there's not that rule at the federal level. Actually, we've got a few justices on our Supreme Court who are in their 80s, and that's not uncommon at the federal level to have justices still serving in their 80s because there's no age limit at the federal level, whereas at the state level, they basically tell you once you get to this age, this is what's going to happen. So there's a lot of differences, but that is the process I went through to become a state court judge. Other questions? Yes, sir.
Out of the Bill of Rights, which one of the amendments you find the most important?
Well, I can tell you the ones that kind of generate the most cases, at least at the state court level, is the Fourth Amendment. The Fourth Amendment talks about illegal searches and seizures. And what that amendment says is that you need probable cause and warrants, unless there's certain exceptions that have been recognized. So oftentimes what we're seeing in state courts is there was some type of search of the house or seizure of a person without a warrant. And then the question becomes, is this one of those cases where there's an exception, where the officer didn't need a warrant in this particular circumstance? Or is this one of the cases where the officer should have gotten a warrant? And the reason that happens a lot is that the defendant, if they can prove that an officer, and actually in a lot of cases it's the officer who has the burden of proof, and the state who has to prove that the search or seizure they did was allowed, that they didn't have a warrant for it. So if the state can't prove that, the search or the seizure gets thrown out, and so does everything that came after it. They call that fruit of the poisonous tree. So if you searched a house and you found, say, some illegal drugs in there, but the court determines that that search violated the Fourth Amendment, and anything that the officers found during that search cannot be brought into evidence to charge someone with a crime. That's called the exclusionary rule. It's basically the punishment for law enforcement if they do something that's unconstitutional. So a lot of defendants are very interested in challenging if there was a search, was this really constitutional? Because if it wasn't, then the evidence that's found by that search can't be used against them, and many times that means the case gets dismissed. So I would say, at least at the state court level, we do see a lot of Fourth Amendment searches and seizures. At the federal court level, there's a lot of First Amendment cases about freedom of speech. First Amendment also protects religious liberty. There's been a lot of Supreme Court cases lately about how far does religious liberty go and what does it allow and what doesn't it allow. So I would say at the federal level, you see more First Amendment cases probably than anything else, because again, religious liberty, freedom of speech, freedom of the press, freedom of assembly, the First Amendment covers a lot of things. And again, the Supreme Court's viewing the whole country as opposed to just one state. So you probably see that issue the most there. Yes?
As a judge, when law enforcement brings a warrant, like a search warrant for you, what things are you looking for when you decide whether you should sign off on it or not?
Sure, well, that's a good question. When law enforcement prepares a search warrant, what they have to tell me is what information they have that leads them to believe that evidence they're looking for is going to exist to where they're looking for. So first, I'm just looking at a very basic level of what information do they have, and is there a link with the information they have to either a residence or a person. It's got to be something more than just a general speculation. Now, sometimes the information contained in the search warrant contains information from a confidential informant. So then what I'm looking for is, have you used this confidential informant before? Are they reliable? Without them having to tell me who it is, I want to know, do they have a history of committing crimes of dishonesty? For some reason why I might not believe them. So that's what I'm looking for to determine, how credible might this information be? Is there maybe some other motive with this person? And law enforcement, as they apply for enough search warrants, that they understand the process and they're generally aware of what information they're going to need to put in this document if they want me to sign it. So it's not very often that I say I'm not going to sign this, but that does happen every now and then. And usually what I say is that I just don't believe you have enough information, or there's not enough of a link, or sometimes the scope of what they want to search is a little too broad. If you're searching for a shotgun, you don't need to search in a jewelry box for it because you're not going to find it there. So that's one other thing I'm looking for is, what's the scope of this? Because in essence, when you're signing a search warrant, you're trying to balance a few things. They're balancing the public's right to be safe and to have crimes investigated, but you're also balancing individual rights and liberties that the Fourth Amendment talks about. It doesn't prohibit searches and seizures, so the Fourth Amendment allows it, but you have to determine whether it's reasonable or not. So those are a few of the factors that I look for when I brought some information. Anyone else?
It's been a while since we've had a constitutional amendment. Do you think that we'll see one in ours?
That's a good question. There was some discussion back in, I think it was about the 70s or 80s, about an equal rights amendment that was focused on gender equality. Now, some states passed that, and I think Congress at one point passed it, but they couldn't quite get as many states as they needed. And recently, Virginia ratified the Equal Rights Amendment, and they became, the 37th or however many states you need to get to 3/4 of the state legislatures. But the issue there was Congress ratified this in either the late 70s or early 80s, and other states that ratified it afterwards have since kind of taken back their ratification as the politicians who comprise those state legislatures have changed and said, well, we ratified it in the mid-80s, but now we've decided to unratify it. So there's a lot of questions about, did that amendment really get ratified or not, given the time lapse and given, can a state legislature undo their ratification if enough time goes by? So that's not a provision of the Constitution, but that's probably the one that got closest without actually making it. There's usually some proposals to amend the Constitution floating around, but not many of them get very far, just because, as I mentioned, it's a hard process. I mean, to get 2/3 of both houses of Congress to agree on anything, our country's pretty divided, and there's not a lot of things that 2/3 of both of houses of Congress agree on, and then to get that many state legislatures. Again, as I mentioned, there's a lot of red states and blue states in there that don't see things the same way. So I don't know if we'll have any amendments passed in the near future. Again, there's always people trying, but it's a very difficult process. Yes.
So back when Kamala Harris was still running for the president's nomination, she made the comment that within 100 days, she used an executive order to ban which types of firearms you can have. How does that play out in courts as far as the president makes an executive order that is, either unconstitutional or kind of in a constitutional gray area?
Well, it's very common now, particularly at the federal level, that any law is passed, any executive order is issued, is almost instantly challenged in court. So what will happen is it starts at the district court level, and you challenge some action of the government at the federal district court level in that case. And so it gets tried out, and one judge will make a decision on whether it's constitutional or not. Then for most of the laws that come out of Congress, it gets appealed to the D.C. Circuit Court of Appeals, which is one level higher than the district court. So then they'll make a ruling on whether it's constitutional. And then if the Supreme Court decides to take it, and the United States Supreme Court decides to take about 80 cases a year, and they reject about 8,000. So it's usually relatively unlikely that the Supreme Court's actually going to hear an appeal from an appellate court, but on some of the kind of more controversial issues, such as gun rights and the Second Amendment, they're maybe more likely to hear a case like that. So then it'll go up to them, and they'll make a ruling, and that'll be the last stop. So it is very common today, almost instantly, any law, there's always somebody there who opposes it and is going to challenge it. That's just kind of the way of life in today's world, is that laws get passed and they get challenged, and they've got to go through that court system and get a ruling on whether it's legal or not.
Laws going through that process in the courts, is it still like enacted, or is it like put on pause?
Well, that's a good question. One of the issues floating around in the legal community today is the issue of a nationwide injunction. And what that means is one district court judge in any district in the United States may issue an order saying, I'm staying this law. In other words, it's not going into effect while the appeal process is going through, and it won't go into effect, if ever, until another court says, this is constitutional. So the question is, are district court judges really supposed to have that much power that they can prevent a law passed by Congress? Any district court judge anywhere in the country, that was challenged could simply stop that by issuing a nationwide injunction. So I think that's something that at some point our Supreme Court is going to give a ruling on, whether those types of rulings are okay or not okay. But in essence, that's what will determine, is this law actually going to go into effect or not? Depends on when it first gets challenged. Does that district court judge say, well, I'm going to stay it while it's going through the process, or I'm not going to do it, and it's just going to go through the process and then get its ruling? Okay, well, this may be the sign that we're out of time, but thank you all. I appreciate your questions and your interest.